evening, everyone, and welcome to the second half of Actorage 1, where we will be discussing corporation and cooperatives. Now, my name is Attorney Jennifer Cruz, or you can simply call me Jen, for those of you who do not know me yet. So we'll start with the corporation code, and I will create a series of video lectures similar to what I've done in partnership, but this time I will limit it to a video per title of the corporation code. So for those of you who are with me in Canvas, I have uploaded a PDF file of the revised corporation code. For those of you who don't have access to Canvas or aren't with me in the course but are watching this video, you can check Lawfil, or actually the official Gazette, and just type Republic Act number 11232. I do not suggest that you memorize the provisions verbatim. It's really more about understanding, especially as future accountants. We will be needing a very good grasp of the corporation code in terms of the formation, management, and the dissolution and winding up. No? So I just want you to know that this corporation code is very new. It was just effective last February 2019, and one of the main features or changes of the revised corporation code compared to the corporation code of the Philippines, the previous one, is that now there are OPCs, or one-person corporations. So let's get started. Republic Act 11232. So let's go first to Title 1, General Provisions. So this revised corporation code has a constitutional basis. The Constitution being our main law in the country now. So it's our organic law rather. So under our Constitution, Congress shall not, except by general law, provide for the formation, organization, or regulation of private corporations. So government-owned or controlled corporations may be created or established by special charters in the interest of the common good and subject to the test of economic viability. What does this mean? This means that Congress shall provide for, again, the formation, organization, or regulation of private corporations only by general law. This one, the revised corporation code. So because of this provision of the Constitution, you will notice in Attorney Lacos' notes that he says only public corporations may be created by special law, and that's true. However, for those of you who are reading De Leon's book, although I do not prescribe a particular book, De Leon states that government-owned and controlled corporations are private corporations, actually. If you look at it, they're actually quasi-public corporations. And there is another book that says that. So, for now, let's just stick first to Attorney Lacos' notes now, so as not to confuse you. But later on, if ever there is a need to clarify that point, we'll make sure my fellow professors in Actorage 1 will clarify that matter to you. Okay. So what is the scope of the revised corporation code, or what I might subsequently refer to as RCC? It's actually these numbers 1 to 7. So the revised corporation code is covered by 17 titles, and so please do expect 17 videos. If I can do one video per title. If it's too long, I might have to chop that up. Yeah. Alright, so let's get started. Section 2, Corporation Defined. A corporation is an artificial being created by operation of law, having the right of succession, and the powers, attributes, and properties expressly authorized by law or incidental to its existence. So this definition, much like everything that the RCC will be discussing about, only refers to private corporations. So I will not be discussing public corporations. Again, because the Constitution said that, public corporations may be created by special law. So from the definition under this section, following attributes emerge. No, one is that it is an artificial being. Now, what does it mean that it's an artificial being? Much like in partnership, it is a juridical personality, separate and distinct from its owners. Now, as an artificial being, it has no bodily existence, obviously. Excuse me. You cannot see a corporation walking around. Um, but because it is an artificial being, the implications would be that number one, a corporation cannot be held criminally liable in a sense that the penalty of imprisonment cannot be imposed on it. How can you actually put to jail a corporation? Usually, when you look at the RCC, the penalty of imprisonment is imposed on the corporate officers who are responsible for the illegal act. Now, the corporation can be imposed a criminal fine, criminal penalty of fine because it can pay. As a general rule, also, another implication is that a corporation is usually not awarded moral damages. Now, I don't know if you've gone through this with your previous law professors, but damages under the civil code for moral damages are awarded to those who have a besmirched reputation, wounded feelings, anxiety, loss of sleep. Yan, that's when moral damages are awarded. But again, since a corporation has no feelings, moral damages are generally not awarded. However, there are instances when the Supreme Court did award moral damages. Why? Because a corporation has a reputation, and that reputation can be destroyed. Now, I'll cite one example. No, there's a case called hold on, Jardine Davies Inc. versus Court of Appeals. That case kasi, Pure Foods awarded a contract to FEMSCO. And what happened was that because of this contract, FEMSCO purchased large equipment to fulfill its obligations under the contract with Pure Foods. However, Pure Foods suddenly, unilaterally canceled that contract with the FEMSCO and awarded that contract to another company, itong si Jardine Davies. So now, FEMSCO is asking for moral damages from both Pure Foods and Jardine. To cut to the important part of our discussion, the Supreme Court there awarded moral damages. It ordered Pure Foods to pay FEMSCO 1 million pesos in moral damages because of the reputation of FEMSCO. Particularly, the Supreme Court explained that FEMSCO actually entered into a contract to purchase a large equipment with its supplier. So, naturally, because the contract was cancelled, FEMSCO will not be able to use that equipment and most likely won't be able to pay for it, diba? So, in that case, it awarded 1 million. Yeah. So, you will also see this in Attorney Lacos' notes. And a third implication is that the corporation is not entitled to the constitutional right against self-incrimination. So, what other consequences are there to a corporation being an artificial being? Another one would be, since it's not a natural person, let's see. There is the doctrine of separate liability, where the right to bring actions, a corporation can actually sue and be sued in its own name. So, because of that, you have to be careful that a corporation cannot bring an action for and in behalf of its stockholders or members for the purpose of recovering property which belongs to the stockholders, because it's separate now. Its personality is separate. Let me cite an example or a case on the doctrine of separate liability. So in the case of Sulo ng Bayan Inc. versus Gregorio Araneta, and this is an old case, a 1976 case, I just want to discuss it. Kasi there might be some of you who, like me, love stories. So, in Sulo ng Bayan filed a case against several corporations over a 27 or 28 million square meter tract of land in Bulacan. So, what happened was that the members of Sulo ng Bayan were dispossessed of this property by the respondent corporations, pang Araneta Incorporated, etc. What the Supreme Court said was that, Sulo ng Bayan has no legal standing to file a case against Gregorio Araneta Inc. et al. Because the ones who were dispossessed are the alleged owners, the members of Sulo, not Sulo itself. Since there was no assignment of any rights to Sulo ng Bayan, then Sulo ng Bayan has no legal standing to file a case on behalf of its members. Yeah. Another let's see, feature of the doctrine of separate personality is that the changes in the individual membership do not affect its corporate existence. So that's also part of it. Because it's its own person, whether one of the stockholders dies, does not change the fact that the corporation is still in existence. Another feature of it being an artificial being is that there is the limited liability rule. So this is similar to a limited partnership. Now, ownership of credit or liability for debt does not extend beyond a stockholder's investment. So the liability of contracts and liability for contracts entered by the corporation is generally the corporation's liability alone. And the same rule applies vice versa. The contracts of its stockholders, it's not a contract or an obligation by the corporation. I say generally because there are instances when particular individuals may be held liable, and I will discuss this shortly after this. Another consequence of the limited liability rule is that a corporation's tax liability or tax exemption is solely its own. Meaning, if a corporation is exempt from a particular tax, its stockholders are not. So, for example, dividends paid by the corporation are owned by its stockholders, and any exemption granted to the corporation cannot be applied to the taxes that the stockholder must pay on the dividends it receives. All right, and then there's another one, another implication, which is the trust fund doctrine. Now, under the trust fund doctrine, it means that the assets of the corporation are considered trust funds reserved for the payment of liabilities to creditors of the corporation. Mainly because the stockholders who have custody or possession over it are not owners thereof. No? They're only holding it in trust for the corporation who keeps it for payment of the creditors. All right, and the last one, the last implication or the last consequence of it being an artificial being is the doctrine of piercing the veil of corporate fiction. Okay, this might be a bit long, but it's extremely simple. When we talk about the piercing the veil of corporate fiction, this is an exception to the doctrine of separate liability. Yeah. So usually there are 4 cases when this doctrine, the doctrine of piercing the veil of corporate fiction, applies. 1 is in fraud cases. 2 is in alter ego cases when the corporation is just a mere instrumentality or alter ego of the stockholders or the owners. 3 is to defeat public convenience. So usually when it's used to evade a tax liability or to justify a wrong or defend a crime. And the 4th is in equity cases, usually in labor. And I've actually read the cases disclosed or enumerated by De Leon. You don't need to memorize them, but I read the full case just because I want to show or I want to clarify more on these 4 types of instances when the doctrine of piercing the veil of corporate fiction applies. Okay, so for example, in the case of Marvel Building Corporation versus David, which is a collector of the BIR back then, the BIR attempted to seize 3 buildings. Even I don't know these buildings because these were right after the war. These buildings kasi were alleged to be owned by a certain Maria B. Castro, and Maria B. Castro had war profits tax case or liability in the amount of around 3.6 million in 1950. So do note that's a huge sum of money back then. Plus, this is the first time I've actually ever heard of a war profits tax. So, it was alleged that Maria B. Castro is actually the sole owner of the corporation. Although there were other stockholders, they made a blank endorsement of their shares to Maria B. Castro. They never had a business meeting, the bylaws were never presented, nor were there any reports of the corporation's affairs. So in that case, what happened was that the Supreme Court said that Marvel Building Corporation was just an alter ego of Maria B. Castro. So that's one case. I even have a picture of one of the buildings. I don't know if that will help. I was just amusing myself. All right, so and there's this other case, McConnell versus Court of Appeals, which is a March 17, 1961 case. Here, the Supreme Court held that the stockholders are individually or personally liable for the corporation's obligations because the corporation is a mere instrumentality of the individual stockholders. It's also a case of alter ego. So in that case, in McConnell, it involved Park Right Inc. It's a business engaged in parking. And a certain Padilla filed a case against Park Right because Park Right was already illegally occupying Padilla's lot for parking. So, Padilla won but only recovered a part of its judgment award. Now, what Padilla sought was to recover the unsatisfied balance with interest from the corporation, its past stockholders, and its current stockholders. So, in that case, the it found that three of the five incorporators actually owned 1,498 of 1,500 shares. So it was saying in effect that it's really not a corporation per se because two of the incorporations or incorporators, excuse me, or are just dummies or nominal. Plus, pero more importantly, what the Supreme Court did, it started enumerating the reasons why it found it to be an alter ego. It did not just depend on the fact that three of the stockholders own a majority. You might wonder kasi if it's not allowed. Here, what the Supreme Court usually does, it doesn't depend on just one circumstance. Here, aside from that fact, Park Right's office was located in the same building and room as the office of its majority stockholders. Number two, Park Right's funds were also kept by its majority stockholder in that stockholder's name. And also, Park Right had no visible assets. So there was no other conclusion but that Park Right was just an alter ego. Okay. In the May 25, 1951 case, Filipinas Compañía de Seguros versus Christian, I do not know how to pronounce this, Wainfeld Company. So, this case was a case about fire, insurance company. So, Filipinas Compañía de Seguros is an insurance company. What happened was that Christian was a company in the Philippines whose building was insured with Filipinas. It burned, and then it sought for recovery on the insurance policy with Filipinas, but Filipinas refused to pay because during that time, it was during the Japanese military occupation. So after that, umabot sa World War II. World War II, if you recall, Hitler, Germany, and Italy declared war in the United States on December 10, 1941. So because of that, us being allies with the US became enemies also, or we were also at war. And this Christian is actually a company owned by a majority, if not all, by German citizens. So because of that, the Supreme Court held that Christian became an enemy corporation when war broke out on December 10. No? So, since the Insurance Act prohibited that an insured be a public enemy, the insurance policy of Christian became void. It could not be enforced anymore. But in the interest of justice, the Supreme Court still ordered Filipinas to return the premiums paid by Christian. Yan. Okay, I'll give an example on how the Supreme Court pierced the veil of corporate fiction when the corporation was used to defeat a public convenience or to escape liability. So in the case of Palacio versus Feli Transportation Company, this is still old, 1962 case, a jeep owned by a certain Kalingasan ran over a child, the child of Gregorio Palacio, the petitioner in this case. So, Gregorio is actually just a welder. Because his son was hospitalized due to fractures, he was forced to close shop temporarily and sell his equipment at a loss. So instead of 350 pesos, he was only able to sell it for 100 or 150. Now, he was now seeking for compensation from Kalingasan, the owner of the jeep. And he also filed a criminal case against the jeepney driver. So because the jeepney driver was held criminally liable for negligence, by law kasi, even the owner, the registered owner of the car, is subsidiarily liable for civil damages, no? So, in that case, Kalingasan was saying that he is not liable because the jeep is now owned by Transportation. Now, here it was discovered that Feli Transportation was used to defeat public convenience because, number one, Kalingasan only incorporated Feli Transportation after the conviction of the jeepney driver. Therefore, it is presumed that Kalingasan incorporated Feli Transportation to evade liability. And second, Feli Transportation actually had no other property other than that jeep. And third, Ferry Transportation's incorporators were actually Kalingasan himself, his wife, and his children. So it was these three instances that led the Supreme Court to believe that it was only created to defeat public convenience or so that he will not pay Palacio. There is a case that was cited actually by two or three of the books that I'm currently reading right now. It's Utivo Sons Hardware Company versus Court of Tax Appeals. This is a January 28, 1961 case. So, in this case kasi, Utivo Sons Hardware Company was found liable for sales deficiency tax of 2.2 million from 1947 to 1950. And this tax deficiency were over cars it purchased from General Motors. General Motors, for those of you who are familiar with GMC, the car, no, it's a US company selling cars like Yukon. It used to import cars here in the Philippines. So, General Motors would import cars, pay customs fees, and then sell it to Utivo. Utivo then sold it to Southern Motors, and Southern Motors sold it to the public in Visayas and Mindanao. So, in this case, the Supreme Court ruled that Southern Motors is just a mere instrumentality of Utivo. So, the Supreme Court held that although Southern Motors was not incorporated for the purpose of evading Utivo's tax liability, several circumstances led the court to conclude that Utivo treated Southern Motors as a mere department or a mere subsidiary or branch. So, the reasons why the Supreme Court held that even if it was not created to evade liability, it is the corporate fiction of Southern Motors was pierced and the two companies were treated as one was because number one, Utivo, who is a person, actually paid for the additional subscription of Southern Motors capital stock. Two, Southern Motors shareholders were merely nominal shareholders holding stocks for and in behalf of Utivo. Three, any transfers of stock between Southern Motors were actually just between immediate relatives. Four, a management contract was entered into between Utivo and Southern Motors where the controlling majority of Utivo Sons Hardware's board of directors is the same as that of Southern Motors. And number five, all of the cash transactions of Southern Motors were handled by Utivo. So because of that, the Court of Tax Appeals properly treated Utivo Sons and Southern Motors as one entity and uh, computed at its tax liability as one entity. So if you just want to skip on all the cases, please do fast forward. But for those of you who might in the off chance still be interested in listening or in picking up law in the future, at least you know how the Supreme Court usually thinks, no? Okay, in another case, in Villaray Transit Inc. versus Ferrer and Pangasinan Transportation, for those of you who are familiar, ano ba to? Pantranco, Pangasinan Transportation Company. So this is a 1968 case that involved the sale of certificates of public convenience. Certificates of public convenience is an authorization by the government for a corporation or a company to operate land transportation. Now, what happened was that Pantranco purchased two certificates of public convenience from a certain Villarama. And in that agreement, Villarama was not to engage in the same business or seek for another, what do you call this? TPU, Temporary Public Utility Service. Now, Villarama, in less than 3 months, created another corporation and actually did. It violated its contract. So, of course, Villarama is now trying to evade liability by saying, I didn't violate the contract because it was actually Villaray Transport that got another TPU, not me. In that case, the Supreme Court held that Villaray Transit is an alter ego of Villarama. Therefore, Villaray is bound to comply with the agreement between Villarama and Pantranco. So even if Villarama was not an incorporator of Villaray, several other factors showed that Villaray was still an alter ego. Why? Because Villarama's wife was the treasurer. Number 2, the checks for the subscription of Villaray Transit was actually the stocks of Villaray were purchased using the personal check of Villarama. His excuse na, I don't know, my wife just hands me money, I didn't know it was Villaray's, was actually a flimsy excuse that the Supreme Court did not buy. In that case, the Supreme Court held that it's obvious Villaray is actually Villarama's company because he commingled his personal funds with it also. Okay, and last, so another case, Claparols versus Court of Industrial Relations, is a 1975 case. In that case, a union meaning a group of employees of Claparol Steel and Nail Plant filed for an unfair labor practice against the company because the company was committing acts of union busting, meaning they were trying to remove officers of the union. Companies kasi usually don't want a union to form between its employees. Now, what happened was that with the labor court back then, now the NLRC, they were ordered reinstated, yung mga employees who were dismissed. And they were told to pay the dismissed employees back wages from the time they were dismissed. Claparols now didn't want to give back their full back wages because he said that Claparol Steel and Nail Plant did not exist anymore. What was then in existence was Claparol Steel Corporation. The Supreme Court sided with the employees and held that the second corporation was a continuation of the and successor of the first because in that case it was just created to avoid its financial liability. They were owned and controlled by the same Eduardo Claparols, and there was no break in the continuity of both corporations. In fact, all of the assets of the first were turned over to the second. So at least now you know, piercing. So let's continue. What are the other attributes? It is created here, as per the definition in section 2, it is created by operation of law. What does it mean? This actually refers to the concession theory that a corporation owes its existence to the law and the state, and that its powers is fixed by the law. So, its powers, its attributes, and its rights are only those provided by law or incidental to its existence. Yeah, it's right here, the second part. Okay, there is, however, an exception to this. No? But before anything else, when you say created by operation of law, uh, a corporation cannot come to existence by mere agreement, unlike a partnership. So the special authority or grant from the state is through the revised corporation code. Another There is an exception to the rule, however. It is when a corporation is created by prescription, and so far, this only applies to the Roman Catholic Church. Why? Because we were once a Spanish colony, so for the longest time, since, oh, bear with me, 1800, the Roman Catholic Church has been in the Philippines. Please do not kill me. LaSalle being a Catholic school. Being a LaSallian myself. So I just want to share. I'm reading another book. I just want to add, no? Okay. Number 3, the right of succession. This means that the death, insolvency, incapacity, civil interdiction, or other circumstance involving the corporation stockholders will not cause the corporation's dissolution, unlike in partnership under Article 1830, 1831. No? So, for those of you who remember your midterms, when we discuss automatic dissolution. So, this is one of the changes made by the revised corporation code. Under the corporation code prior to February 2019, a corporation only had an existent, a corporate life of 50 years. Now, under this new law, the general rule is that if the articles of incorporation do not give a limit, a corporation now exists perpetually. Oh, why is that? Because usually most businesses would want to exist for life, no? So may forever pala dito sa revised corporation code. Mainly because the death of the stockholders will not affect the corporation anyway. So what are the examples? San Miguel has been here for so long. Petron also has been in existence for so long, among many other things. Yeah. So later on, we will discuss the corporate term for one, new corporations organized under the revised corporation code, and two, corporations under the previous law who want to extend or what we call revive. And you will see this in Attorney Lacos notes under corporate term, pages 1 to 2. No. So I will just discuss that later on. Okay. Now, number 4, it has powers, attributes, and properties expressly authorized by law or incidental to its existence. What do these powers cover? It covers express, implied, and incidental. It says right here. Yeah, express, incidental, or implied, no? So, what does it mean when we talk about the last part of Section 2? It means that a corporation does not have the unlimited power to act. The grant that must be given by the state need not be expressed, though. So, all powers which may be implied from those expressly granted by law, which is under the RCC, may be exercised. What are these? So, when you say express, we already know these are under the RCC. What are implied or necessary? For example, under De Leon's book. The reason why I'm citing De Leon is so that I'm not grabbing credit, no? And for those of you who don't need to buy the book anymore. 1. A railroad corporation has the incidental power to build railroads. Number 2. An agricultural company has the implied authority to buy agricultural land. And number 3, a cement manufacturer can operate and maintain an electric plant. Why? Because that electric plant will be used for supplying electricity to its cement factory or to its stay-in employees. Usually, these manufacturing companies have an area for their employees to stay in. Now, what is not implied or necessary to its existence? An electric company cannot buy and sell agricultural land, and neither may an automobile company engage in land transportation like the operation of a taxis. because it's not necessary with the company's business of buying and selling cars. And now that we have discussed, so what happens if they act beyond what is expressed, implied, or incidental to its existence? These are what we call ultra vires acts or contracts. Yeah, so that's why Dragon Ball Z is there. So these are acts committed outside the object for which a corporation is created as defined by law. So what is the status of an ultra vires act? Anything outside is an ultra vires act. One, it can be illegal per se, so it's null and void. Number two, it is not illegal per se, but because the corporation failed to comply with the voting requirements by law, it becomes null and void. Yan. So, what are those that have a voting requirements? We will discuss that later on also. And there are also ultra vires acts that are outside the primary and secondary purpose of the corporation. So, it's only voidable. So, let me write that down. For number 3, these are voidable. On whose part? Of course, not on the part of the corporation, on the part of the other party. Because the corporation is now actually stopped from denying its liability under a voidable contract kasi it knew that it acted outside of its primary or secondary purpose. There are also ultra vires acts conducted by the corporate officers in behalf of the corporation. So again, much like number 1, there are ultra vires acts done by the officers which are illegal per se. Number 2, ultra vires acts which are unauthorized, or when the officers exceed their authority. In this case, meaning in a case where it is unauthorized, it merely becomes unenforceable. Meaning it cannot be enforced against the corporation unless, and I will put an asterisk because my penmanship is so terrible, unless there is an express or implied ratification by the corporation, or 2, by the doctrine of estoppel, meaning the corporation through its board represented itself as agreeing to the ultra vires act, or 3, the doctrine of apparent authority of the corporate officer, similar to the doctrine of apparent authority under partnership. Yeah. Let's talk briefly about its advantages and disadvantages. So what are its advantages? Number 1, it has the legal capacity to act as a unit. Number 2, there is continuity of existence, especially now that its existence is presumed to be perpetual in the absence of any contrary agreement in the articles. What does it mean? This means that because of its continuity of existence, it has a strong juridical personality. Number 3, because of its continuous existence, there's actually good credit. It's usually stronger. And 4, there is a standardization of creation, organization, management, and dissolution. Unlike a partnership where we have to determine whether there was really an agreement between the parties to contribute money, property, or industry to a common fund with the intention of dividing profits among themselves. At least this way, you'll just have to check, did the incorporators follow the requirements under the revised corporation code. Number 5, because of the consequences of a corporation, there is now the ability to have a larger financial enterprise because it's composed of several individuals, and actually a corporation can be composed of corporations as well. Number 6, there is a limited liability on the part of the shareholders. Unlike in a partnership, you remember a limited partner can be liable for personally if they partake in the management of the partnership, or if their name is in the firm name and there are no exceptions. Here, a shareholder's liability is definitely limited unless you're gonna pierce the veil, which we just discussed. Number 7, they are not general agents of the business. since a corporation, as previously mentioned, acts through its board or officers, board of directors, board of trustees, or officers. Unlike in a partnership, where if you remember Article 1818 of the Civil Code, partners are agents of the partnership. Number 8, there is ease in transfer of shares of stocks, since there is no need for the consent of other stockholders, as long as you comply with the requirements usually in the bylaws on how transfer of shares would be done. And number 9, there is ease in raising funds. But of course, like life, nothing is perfect. There are also some disadvantages to deciding in creating a corporation instead. Okay. Cute ng GIF ko, no? Jiffy pala. What are these disadvantages? Well, number 1, the formation and management is relatively complicated given the number of requirements under the RCC. Number 2, it's more costly given the number of documents that must be prepared. Usually, although you don't need to, usually you hire a lawyer and an accountant. Plus, you have to pay for documentary stamp tax on the documents you need to file, and other small expenses. Plus, taxes, like what was mentioned in Attorney Laco's notes, there is indirectly some sort of a double taxation. Number 3, although credit was previously mentioned as a good thing, it can also be a bad thing. The fact that a stockholder's liability is limited can also act as a deterrent to creditors because they know that their rights are only as against the corporation's property alone. Number 4, there is the lack of the personal element. There is no delectus personae here because of the ease in transferring shares. So you do not have the freedom to choose who you associate yourself with in a corporation. Number 5, there is greater government control. Plainly, I think because of the limited liability of shareholders, plus the scale of the financial transactions, and the ease of changing stockholders, it's one of the reasons why there is greater governmental control in corporations. And 6, voting rights. So here, there is little voice for most of the owners. Voting rights have actually become theoretical in large corporations because of the use of proxies, which we will discuss later on. So their voice in the conduct of the business is not as significant as in partnerships. And lastly, it's actually a disadvantage because ownership does not necessarily, lead to management and control. Now that we have already discussed about the definition of a corporation and already dissected its definition, we can now compare a corporation and with a partnership. So let's go first to the differences. As to the manner of creation, if you remember, under Article 1767 of the Civil Code, a partnership is created by mere agreement of the parties, whereas a corporation is created by creation of the law. Second, as to the number of incorporators, in a partnership, it can be established between 2 or more persons. On the other hand, a corporation can now, especially under the RCC, can now be established by a one-person corporation. In cases where there are at least 2 people, it should not be more than 15, and we will discuss this later. Number 3, as to the commencement of the juridical personality, a partnership commences to acquire juridical personality from the moment of the execution of the contract of partnership, which need not be written, as we've mentioned before, whereas a corporation begins to have a corporate existence or a juridical personality only from the date of the issuance of the certificate of incorporation by the Securities and Exchange Commission under its official seal. And once again, we will discuss this later. As to the powers, I'm running a bit late, so I'm trying to make it as fast as I can. As to the powers, a partnership may exercise any power authorized by the partners, provided it's not contrary to law, morals, good customs, public order, or public policy, which is under the Article 1306 of the Civil Code, whereas a corporation, as mentioned in Section 2 of the RCC, can only exercise powers that were expressly granted to it, or implied, or necessary, or inherent to its existence. Number 3, as to the management. In a partnership, when the management has not been agreed upon, all partners as agents of the partnership may manage the business, whereas in a corporation, its power is vested in its board of directors. Number three, as to the right of succession, a partnership has no right of succession. If you remember, the death, insolvency, insanity, civil interdiction causes, among other things, causes the dissolution of a partnership. Whereas in a corporation, it has perpetual existence now. Number eight, the extent of liability of third persons. In a partnership, partners are, except limited partners, are personally liable and subsidiarily liable. In fact, there are times that they are actually solidarily liable, meaning you don't have to wait for partnership assets to be exhausted. Whereas in a corporation, stockholders are liable only to the extent of their investments, as represented by the shares they subscribe to. Number nine, in terms of transferability of interest, a partner cannot transfer without the consent of all others. So, because if you remember, a partnership revolves around the principle of directus personae, whereas in a corporation, there is an ease in the transfer of shares without requiring the consent of its other stockholders. As to the term of existence, a partnership may be established for any period of time, usually within the life of the partners, whereas a corporation now has perpetual existence. And as I will be discussing later, corporations that were created prior to the RCC can actually be revived or extended further to have perpetual existence, unless the articles of incorporation provide that they will have only a particular period. Number 11, firm name. A limited partner must have the word limited or LTD to its name, while a corporation may adopt any firm name that is not identical or deceptively similar to any registered firm name. So, usually what happens is that if you are forming a corporation, much like a sole proprietorship, for sole proprietorships kasi you need to go to the DTI website, you can do that. But for corporations, you go to the SEC website. As of the moment, it's a bit down, but you can check your name and see if it is similar to any. If it is kasi the registration of your corporation will be rejected. So usually they require a clearance, so you have to check their database for that. Number 12, for dissolution, it's already under 1830, 1831, and 1838 of the Civil Code for partnerships, whereas a corporation can only be dissolved with the consent of the state, and we will discuss that when we get to the latter part of RCC. And for the laws that govern, obviously, partnership is by Civil Code, whereas a corporation is governed by the RCC. All right, now that we have discussed the differences with a partnership, let's talk about the similarities. Okay, so for similarities, ayan, napagod na yung mga minions. Sorry ha, I'm more amused with this. So, in terms of the similarities, number one, they both have a separate juridical personality. Number two, both a partnership and a corporation acts through its agents. Now, as to who the agents are, they're different. If you remember, again, I will mention under Article 1818 of the Civil Code, the partners are the agents of the partnership, whereas in a corporation, its agents are the board of directors. Okay. But in any case, the reason why they are similar is because both partnership and corporation can only act through its agents. Alright, another similarity is that in a partnership is organized, and a corporation generally is organized through the congregation of two or more persons. Why are there two asterisks here? I put that here because now there is a one-person corporation. So it's not exactly a similarity in a sense that there can be a one-person corporation and there's no such thing as a one-person partnership. Excuse me. Alright, number 4. As both partnership and corporation are created for the distribution of profits, with the exception of general professional partnerships, we're only talking about the general similarities. Both a partnership and a corporation are generally created for the distribution of profits. Number 5, as to the creation is both by law, although we're talking about different laws. And number 6, As to the taxability, both a corporation and a partnership are taxable as a corporation. Where can you see that? You will see that in Section 22B of the National Internal Revenue Code, which is now the Train Law, amended by the Train Law. So again, a partnership except a general professional partnership is taxable as a corporation. Now let's move on to Section 3, Classes of Corporations. Corporations formed or organized under this code may be stock or non-stock. Stock corporations are those which have capital stock divided into shares and are authorized to distribute to the holders of such shares dividends or allotments of the surplus profits on the basis of the shares held. All other corporations are non-stock corporations. Therefore, stock corporation is the ordinary business corporation created and operated for the purpose of making a profit. Looking at Section 3, there are two elements to make a private corporation a stock corporation. Number one, that they have capital stock divided into shares. And number two, that the distribution of dividends or allotment of surplus profits are on the basis of the shares held. On the other hand, non-stock corporations are usually for the public and welfare, public good and welfare. Their capital are sourced from contributions and donations and are governed by a different section of the RCC, which we will discuss later on. So although the RCC classifies corporations into stock or non-stock, similar to partnerships when we discussed on the first half of the semester, there are also different ways of categorizing corporations depending on which factor we are considering. So these are the ones under Attorney Lacos notes. Number one, I'll add this. Number one, as to the number of persons, there is a corporation aggregate and a one-person corporation. As to the nature of the information of the corporation, there's a public corporation, meaning a corporation created by law. It's created for political or public purpose connected with the administration of the government. So, examples of public corporations are provinces, cities, municipalities, the administrative region of Muslim Mindanao, and the Cordillera Administrative Region. So, these public corporations are also called municipal corporations or local governments. On the other hand, according to Attorney Laco, another public corporation is the GOCC or the Government-Owned and Controlled Corporation. It's created by special law for for public purpose but performing proprietary or commercial functions. In another book, it is actually classified as a private corporation. So we'll again, as I've mentioned earlier, we will clarify that. No, we want to have a uniform answer when it comes to this. Should it be asked in the board exam? Under De Leon, GOCCs, government-owned and controlled corporations, can be created either by special law or under the revised corporation code, but owned or controlled by the government. It can, so when we say owned and controlled by the government, it can be directly through a parent corporation or a subsidiary corporation to the extent that at least a majority of its outstanding stock are owned by the government. So be careful, these GOCCs may be stock or non-stock and may perform either governmental or proprietary functions. They are still considered private because they are not established for the government. For example, the GSIS, the government's SSS, the National Power Corporation, the Philippine North Railway Corporation, PNR, and the PCSO, the Philippine Charity Sweepstakes Office. Also, as opposed to a public corporation, there's a private corporation. And under the private corporation in Attorney Lacos notes, there's the civil corporation for profit and a quasi-public corporation, a public utility. It's a private corporation owned by private individuals but performing an essential government function like buses. No? And also, there's another one, corporation by prescription. It is created by the lapse of time. So it's the only corporation that obtains juridical personality even without franchise granted by the state or even without the filing of the Articles of Incorporation by the SEC. And again, as I've mentioned, the only thing that we know of right now is the Roman Catholic Church. As to the purpose, there are four. There's the civil, meaning civil corporation is created for profit. There is a lay corporation, which is created for a purpose other than religion. And there's an eleemosynary corporation, which is created for charity. And there's an ecclesiastical or religious corporation, meaning it's created for a religious purpose. So if you're talking about a religious corporation, it can be a corporation sole like the Roman Catholic Church, which is headed by the Pope, and a corporation aggregate or a religious society. All right. Now, as to a corporation being subject of a direct attack by the state, there are three. If you are talking about a de jure corporation, a de jure corporation is one that exists in fact and in law. So it has a separate juridical personality that is not subject to the direct attack by the state. As opposed to number two, a de facto corporation, which is a corporation in fact but not in law, and it's governed by Section 19, which we will discuss later on. Its juridical personality can be subject to the attack by the state, but only through a special civil action called quo warranto proceedings, and that's under the revised under the rules of court, excuse me. And number three, there is an ostensible corporation or a corporation by estopel, which is not actually a corporation since it does not have a charter, but the persons are liable as general partners. If you remember, it's similar to Article 1825 of the Civil Code when we were talking about partnership by estopel. So, when that ostensible corporation is sued on any transaction entered into it as a corporation, it shall not be allowed to use its defense that it's not a corporation or it does not have a corporate personality. On the other hand, the persons who entered into the contract as alleged shareholders or board, they cannot resist performance of the obligation by saying that there is no such corporation because they're all stopped. In other words, you cannot deny what you have already represented yourself as. It's as easy as that. Okay. Now, when it comes to the nationality, under the doctrine of incorporation, it means that the nationality is determined by the place of its incorporation or the law that created it. Therefore, there are two types. A domestic corporation created under our RCC. It is no longer required to obtain a license from the SEC to engage in business. It may be sued and it may sue in Philippine courts. And if, as opposed to a foreign corporation, which is created under the law of a different country. So here, a foreign corporation is required to obtain a license from the SEC before it may engage in business. Number two, it must also appoint a resident agent before it may be given license. Because otherwise, it would be difficult to transact with a foreign corporation if it has no point person here. Secondly, it's also difficult to sue that foreign corporation or to expect its fulfillment if there is no agent. So, number one, there is a right to sue foreign corporation not doing business in the Philippines before Philippine courts for isolated transactions. For example, usually for power plants, a Philippine corporation will be given authority to put up a power plant, but usually domestic corporations do not have the expertise or the equipment to do so. So it will enter into a joint venture with a foreign corporation. In that case, that foreign corporation is just doing this one transaction, the creation of a power plant. That's an isolated transaction. And it can be sued on the basis of such isolated transaction. And a foreign corporation can also sue Philippine courts for violation of its intellectual property rights. So, as we all know, Filipinos are very ingenious when it comes to mimicking, say, for example, McDonald's, diba? So, there, that's just one, no? Among many other things. And also, for counterfeit products, foreign corporations may sue, say, Louis Vuitton, no? Number two, there's a right to sue or personally be sued. Um, if it has a license also here. And number three, for those foreign corporations doing business without licenses, they can be sued, but generally they may not sue, except in case of estupel. So, why in cases where a corporation conducts business without a license, it is but logical that that corporation can be sued but cannot sue. Otherwise, it would be so unfair. It doesn't have a license, it does business here despite not having a license, and then it still has the right to sue. So generally, it may not. However, it must obtain the necessary license and submit proof of its compliance with the requirements of the law before it can sue. So, after all that compliance, dun pa lang siya pwedeng mag-sue, no? Alright. Now, there is a test of nationality, and I just want to briefly discuss that. For those of you who might be reading Soriano's book, and I am not endorsing this, I'm just mentioning where I got it, there is the incorporation test and the control test. So, under the incorporation test, the nationality of a corporation follows that of the country under whose laws was incorporated, which is exactly what we just mentioned. Now, there's another one. There's the control test. It meaning the nationality of a corporation follows that of the stockholders owning controlling interest. So, this is applied during wartime for the purpose of the security of the state. Much like if you remember what I discussed with you a while ago when it comes to piercing the veil. Tama ba? Or no, when it comes to when it I mentioned it earlier with the case of Filipinas Compañía de Seguros versus Christern Wainfeld, where Christern became a public enemy corporation because most of its stockholders are German nationals. So, that's one case, no? Even if that corporation was formed under our jurisdiction, it shall be considered a foreign corporation if controlled by foreigners. So, it's usually, this is, if for those of you who plan to take up law, you will be hearing this. It's the grandfather rule. It's a method by which the percentage of Filipino equity in corporations engaged in nationalized or partly nationalized areas of activities like media must be 100% Filipino. So you will see that in the Constitution. In these cases, the grandfather rule is applied in order to ensure that these protected industries are following the constitutional mandate when it comes to the required percentage of Filipino ownership. Okay, so this is because the presence of corporate stockholders with alien stockholding would, as a result, diminish effective control of Filipinos if we don't apply that grandfather rule. Kasi usually, under the Constitution, there must be a 60-40 ratio, 60% Filipino, 40%. Again, as I mentioned, with the exception of some corporations that require 100%. So if you remember, when it came to ABS-CBN's franchise, there was some discussion about ownership because there was some in because they were alleging that there is actually foreign control over ABS-CBN. Okay. Now, number 6, as to the control, there are also 4. And please pardon, I forgot to write it down. 4 also. I will not write down na how many each have. Number 1, there is the holding or parent corporation, the one that controls another corporation. Therefore, on the other hand, there is the subsidiary corporation or the corporation that is being controlled by the parent. Number 3, there is an affiliate corporation, which is meaning it is a member of a group of companies. For example, what can I remember? Say, Yellow Cab, Teriyaki Boy. I'm thinking about what I usually take out. They're usually an affiliate group of companies. Max's Restaurant, if I'm not mistaken. And associate is a corporation being significantly influenced by an investor. That's an associate. So if you have any questions, just feel free to message me through Facebook or just email me at my email, my DLSU email, jennifer.cruz. Alright. Now, when it comes to the presence of stocks, number 7, whether it is open to the public or not, there is an open corporation and a closed corporation. When you say closed corporation, it is limited to selected persons or members of a family, and this is covered by sections 96 to 105 of the RCC. And conversely, an open corporation is a corporation open to anyone. Alright, now number 8, as to the presence of stocks and distribution of dividends, there's a stock corporation, as mentioned under Section 3, non-stock corp, and a non-stock corporation. So just read the notes of Attorney Laco when it comes to converting a non-stock to stock or a stock to a non-stock. I'm sure we will discuss this later on when we go to that exact provision. Okay. I just want to briefly go over Section 4, corporations created by special laws or charters. So we have mentioned these are GOCCs. Corporations created by special laws or charters shall be governed primarily by the provisions of the special law or charter creating them or applicable to them, supplemented by the provisions of this code insofar as they are applicable. So what I just want you to remember is that although these GOCCs are governed by their charter, the RCC still applies, but only to supplement. Meaning, if there's nothing in their special charter that says about a power, you can refer to the RCC if it's not inconsistent with their special charter. Now, we go to the types of persons involved in a corporation. Under Section 5, there are corporators and incorporators, stockholders, and members. So corporators are those who compose a corporation, whether as stockholders or shareholders in a stock corporation or as members in a non-stock corporation. Incorporators are those stockholders or members mentioned in the Articles of Incorporation as originally forming and composing the corporation and who are signatories thereof. Therefore, my apologies for any inaccuracy or ugliness in making this. So, this is a Venn diagram. Just for illustration purposes, a corporator is all-encompassing and includes an incorporator. I'll just put INC, and a shareholder or a member. So why did I do this? It's because not all shareholders are incorporators, and not all members are shareholders also. So there can be an instance where an incorporator maintains itself as a shareholder. Remember, because of the ease in transferring ownership of stocks, an incorporator does not necessarily stay as an incorporator forever. They can leave, no? And also, although it's not stated under Section 5, there are also other classes of persons. And I'll just write them outside. These are promoters. Sorry, I'm left-handed. And underwriters. So the reason why I'm placing them outside the Venn diagram is because they are not corporators under the definition on Section 5. Not necessarily, actually. And subscribers. Yeah, another one. Yeah. So, what is a promoter? A promoter is someone who a natural or juridical person who usually discovers a business and brings interested person. So literally, they're promoting the corporation. So they're the ones who recruit people who want to invest initially, Although the law does not require a promoter, usually it's to facilitate in the creation of a corporation, especially if you want to create a large corporation. And it may be difficult to find investors. Usually, promoters have the necessary connections already. So they also help sometimes in the management of the pre-incorporation contracts. No? So a promoter actually has liabilities on contracts. And as I've mentioned, these are pre-incorporation contracts. Promoters are personally liable for contracts made for the purpose of for the benefit of the proposed corporation. If the corporation is not materialized yet, the promoter remains personally liable. When does a promoter when does the corporation become liable? When the corporation ratifies or adopts that contract, which is usually when the corporation already has its existence. So, and if you remember what we mentioned earlier, that's after securing the necessary documents from the SEC, no? So, and another instance where a promoter will not be liable is if the third person, the one who they are um, in a contract with, agrees to absolve that promoter already. Therefore, a newly formed corporation is not automatically liable for pre-incorporation contracts entered by the promoter. It will be only liable upon the adoption, ratification, or novation of such contract. What are subscribers? Which we will discuss later on. Subscribers are those who agree to take and pay original unissued shares. Subscribers are not yet stockholders, and that's the reason why they are outside this Venn diagram. They are not yet subscribers until they are not yet stockholders until their subscriptions are actually accepted by the corporation. And lastly, there are underwriters. These are usually investment bankers, but does not necessarily have to be so. They usually agree to buy an entire share of securities or a substantial part, much like a scalper. So they'll buy it already and they'll just resell it, or they will guarantee the sale, meaning they will help sell, or they won't, but they will promise that we will buy any unsold portion. That's what I mean when they say guarantee. Or they can agree to use their best efforts to market it, or they will offer for sale a stock that they purchased from a controlling stockholder. Let's move on to Section 6, or classification of shares. Please do not be daunted by how long this provision is, especially with Attorney Lacos mnemonics. It's actually relatively easy. So Section 6 talks about the classification of shares. The classification of shares, their corresponding rights, privileges, or restrictions, and their stated par value, if there is a stated par value, must be indicated in the Articles of Incorporation. So, must. Oh, excuse me. Each share shall be equal in all respects to every other share except as otherwise provided in the Articles of Incorporation and in the in the certificate of stock. So this is a presumption that in the absence of any agreement in the articles and in the certificate of stock, each share shall be equal. Please note that while the classification and the rights and the stated par value must be stated in the articles, when it comes to sharing, it must also be stated in the certificate of stock. So shares in stock corporations may be divided into classes or series of shares or both. No share may be deprived of voting rights except preferred or redeemable, unless otherwise provided in this code. In any case, there shall always be a class that has complete voting rights. And usually these are common stocks. Now, the first mnemonic that Attorney Laco has, the I am sad, if you will remember, under page 5 of his notes, it's actually the ones under letters A to H, meaning even if a stock is non-voting, it shall be entitled to vote on the following matters. The I am sad, no? So that's incurring, creating, or increasing bonded indebtedness, increasing or decreasing capital stock, investment of corporate funds in another corporation or business, and I will not mention anymore everything. So if you look at Attorney Laco's notes, the mnemonic grade are corporate acts which non-voting preferred shares are not allowed to vote on. So if I may just enumerate these, the corporate acts which non-voting preferred shares are not allowed to vote: G for granting of compensation to directors, R for removal of directors, another R for ratification of disloyalty of directors or voidable contract involving self-dealing director or interlocking director, A approval of management contract, D distribution of stock dividends, and E election of directors. So, except as provided in the immediately preceding paragraph, the vote required in the code, meaning except for A to H, the votes required in the code only refer to stocks with voting rights. The shares or series of shares may or may not have a par value, which I already mentioned, provided that, okay, for this part, comes in Attorney Laco's other mnemonic. I love it because mnemonics really help memorize. The BLTB people. If you remember the banks and loan associations, trust company, building and loan association, trust company, bank, public utility, insurance, pre-need companies, and other corporations authorized to obtain or access money from the public, whether publicly listed or not. So that's in his notes also. So these shall not be allowed to issue no par value shares. BLTB people must always have par value shares, must issue par value shares. Now, when it comes to preferred shares, it is covered by the third to the last paragraph. They may be given preference in distribution of dividends or in the distribution of corporate assets in case of liquidation, or both, or other preferences, provided that preferred shares of stock may be issued only with a stated par value. So that's another one that cannot be issued without a par value. Preferred shares. The board of directors, were authorized in the articles of incorporation, may fix the terms and conditions, provided that such terms and conditions shall be effective upon filing of a certificate with the SEC. So, shares of capital stock issued without par. So, this penultimate paragraph talks about no par value, shall be deemed fully paid and non-assessable, meaning, and I will explain this later, and the holder of such shares shall not be liable to the corporation or to its creditors in respect thereto. Provided that no par value, shares must be issued for a consideration of at least 5 pesos per share. Provided further that the entire consideration received by the corporation for its no par value shares shall be treated as capital and shall not be available for distribution as dividends. A corporation may further classify its shares for the purpose of ensuring compliance with constitutional or legal requirements. Okay. So, shares of stock usually differ with respect to voting rights, dividend rights, and in case of liquidation rights to corporate assets. Since the classification must already be indicated in the articles, then its incorporators are the ones that originally determined the classes and the numbers of a corporation's shares. This does not mean, however, that once the classification is made, it cannot be changed. It can. Please pardon my retainers. Later, we will discuss under Section 15 when the articles of incorporation may be amended. And in that case, when the shares will be reclassified or changed, then it requires an amendment. Those who are against any amendment to the articles of incorporations, like if the shares were changed, may actually dissent and they actually have proper remedies under Section 81, which I will not discuss yet. So if it can be changed, why there even a need to classify them from the beginning? Number one, there is the compliance with the legal requirements, like requiring a percentage of capital stock that must be Filipino. If you remember, domestic corporations must be 60-40. Under the Constitution, as I earlier mentioned, there are some industries must be 100% Filipino owned. So usually Class A are usually exclusively for Filipino citizens or domestic corporations, while Class B are for Filipino citizens and foreigners. And number two, there is a need to classify from the beginning for monitoring purposes also. So each share shall be equal in all respects. What I mentioned earlier, this portion, this actually embodies what we call the doctrine of equality of shares. I will say that again, that is the doctrine of equality of shares. It is a presumption. Why? Because it can always be there can always be unequal sharing if it is stated in the articles and in the certificate of stock. So the terms covered by this section, preferred shares, you already know, as I'm sure, from your basic accounting, but briefly let's go over them again. So let's talk about some terms that you have already, and I'm sure you already know from your basic accounting courses. Number one is capital stock. Capital stock, as we all know, is the amount fixed in the Articles of Incorporation to be subscribed and paid in by the shareholders either in money or property or labor or services at the organization of the corporation or afterwards. So it is the equity of the stockholders paid in the paid to the corporation. So capital stock, what is the importance of it? It limits the maximum amount or number of each class of shares that may be issued by the corporation. However, this maximum can be increased or decreased if the articles of incorporation are formally amended, which again, as I mentioned, we will discuss when we get to section 15. So, generally, it remains the same despite the change in value of the shares or despite a company's profit or loss. So, authorized capital stock, before going to authorized capital stock is different from capital per se, or capital. Because capital refers to the entire property or assets of the corporation. It includes distributed earnings less losses and expenses. So strictly speaking, though it refers to the portion of the net assets paid by the shareholders as consideration for the shares issued by them. Legal capital, on the other hand, is the amount paid by the shareholders to the extent of their shares par value only. So it does not include APIC, additional paid in capital, which you always use when you did your first accounting course in LaSalle. So if shareholders pay a premium, the excess is not part of legal capital, which, as I mentioned, is APIC. Now, when we talk about authorized capital stock, this is sometimes synonymous with capital stock where the shares have a par value. If there's no par value, there is no authorized capital stock because there's no monetary value that can be assigned to it. No, it will only have a capital stock. Now, subscribed capital stock is promised whether fully paid or not. There is a subscribed capital stock presupposes an original subscription contract executed. And we will discuss this when we get to sections 59 and 60 on subscription contracts and pre-incorporation subscription. Shares that were originally subscribed and resold are a different matter, and we will discuss this when we get to treasury shares. Now, when we go to outstanding capital stock, it is explicitly defined under Section 173 of the RCC. So these are a portion of the capital stock that is issued and held by persons other than the corporation. So, again, as I've mentioned, this does not include treasury shares. So, because treasury shares, as I will discuss again later, are those issued but purchased by the corporation back. Alright. So when we say issued and held, it does not require that they are fully or partially paid. What is important is that there is a binding subscription agreement. So there's a small difference between outstanding and subscribed capital stock. Now, paid up capital stock, by the very definition, refers to those paid. And unissued capital stock referred to capital stock not issued and not subscribed. So it's fairly easy since you have already discussed this. I have already also included, I don't know if it's clear, an illustration from De Leon. For those of you who don't have the book, and it's okay, just pause the video and read it to see the illustration. Before I move on to the next set of terms, I just want to emphasize the difference between capital and capital stock. So, capital is actual corporate property, whereas capital stock is actually an amount, so it's abstract. You cannot physically see it. A capital, on one hand, fluctuates according to profit and loss or appreciation or depreciation of corporate assets, whereas capital stock is always fixed in the articles of incorporation. Capital belongs to the corporation, whereas capital stock belongs to the stockholders only when it is issued. And capital is real or personal property, whereas capital stock is always personal property. Now, on the other hand, when we differentiate capital stock from legal capital, it's fairly easy, while they both remain unchanged, except when outstanding shares are increased or reduced in number or amount. A capital stock limits the maximum that may be issued without amending the articles of incorporation, whereas legal capital sets the minimum amount, which is for the protection of corporate creditors, since these may not be lawfully distributed to stockholders. So here's another illustration that you may want to look at. I just took a picture. Simply pause the video and read it if you want to go over it. Let's talk about stocks or shares of stocks. Now, stocks represent the interest or right which an owner has in the management of the corporation through the stockholders' right to vote, assuming that they have the right to vote, in the matters prescribed under Section 6. Excuse me. Over a portion in the corporate earnings if and when such portion is segregated in the form of dividends. Meaning, be careful, this does not mean that if there are earnings, stockholders automatically have a right over them. Stockholders, to be clear, do not have an automatic right over a corporation's earnings. There must be a declaration by the board and a segregation of the excess retained earnings for distribution of dividends. And shares of stock also represent an owner's interest or right upon the corporation's dissolution or winding up in the remaining property and assets of the corporation after payment of all corporate liabilities. So what is it? It's a distinct undivided share in the common property of the corporation. So a stockholder is not the owner of any property and is not entitled to possession, unlike in partnership. Since it is an undivided share, it does not represent property of a corporation when we talk about shares of stock. It is personal, incorporeal property versus tangible. So it's intangible property. And they are not debts of the corporation. A stockholder is not a creditor of the corporation. So shares of stocks are those in the hands of stockholders. Now, what's the difference between shares of stock and a certificate of stock, which is the one you see right here? A certificate of stock is a written acknowledgement by the corporation of the interest, right, and participation of a person in the management, profits, and assets of a corporation. So it's a formal evidence of a holder's ownership, and it's used as a convenient way of transferring ownership or transferring title. So shares of stock is intangible, certificate of stock is tangible. Here's something that might be tricky. A share of stock may be issued even if subscription is fully paid, whereas a certificate of stock generally may not be issued unless subscription is fully paid. And you will see that in section 63. Message me please if you have any questions regarding that statement. Now, as to the location of a share of stock is deemed to be where the corporation is domiciled, whereas a certificate of stock, the physical evidence, is deemed to be located at the domicile of the owner. So let us now go to the classes of shares, and I will follow the classification of Attorney Laco. One, as to rights, there are common or common stocks or ordinary shares. These are usually the ones that have all the voting rights, complete voting rights. um, and then there are preferred stocks or preference shares, and preferred stocks, are further classified into cumulative, non-cumulative, participating, and non-participating. So a common stock, just to differentiate it from preferred, are those that entitle the holder to a pro rata division of the profits without any preference over other stockholders or class. So common stockholders are residual owners of the corporation. If there is more than one class of them, and there can be, they're usually designated as class A, B, C, and so on and so forth. As for preferred, there can be different preferences, as mentioned in section 6, preferences to assets in case of liquidation, preferences to dividends, or preference as to other matters stated in the articles that are not violative of the RCC. Okay, so note that if share is a preferred share as to dividends, it only means that there is a fixed rate before dividends are paid to stockholders. It is not a guarantee, again I will repeat, that one will receive dividends, since a corporation is not bound to pay dividends unless so declared by the board. So, preferred stockholders are not creditors or of the corporation. So they are also the same as common stockholders insofar as they are investors. There is an American jurisprudence that if a stock is classified as preferred, it is usually preference as to dividends only and not to assets in case of liquidation. Now, why do I mention American jurisprudence when we are in the Philippines? Number one, because there is no Philippine jurisprudence on this presumption, meaning the presumption that if it is not stated, a preferred share is usually preferred as to dividends only. And number two, we look into American jurisprudence because our commercial laws are based from American jurisprudence. Now, they are rarely given voting rights when we talk about preferred shares, mainly because they already have so much advantages to them already. If there's more than one class of them, they are usually designated as first preferred, second preferred, etc., etc. So what are the limitations to preferred shares? They are deprived of voting rights, except those under Section 6. They may be deprived of voting rights, not always. Their preference should never violate the provisions of the RCC. They may only be issued with par value, and the board may fix the terms and conditions of preferred shares only when the board is authorized under the articles. So these terms and conditions may be effective upon the filing of the certificate with the SEC. Alright, so when you talk about cumulative, it means the holder is entitled to payment of current and dividends in arrears, as I'm sure you already know this. Non-cumulative, on the other hand, refers to current dividends only. For participating and non-participating, participating means they have a right to receive stipulated dividends at the preferred rate, and aside from that, they have the right to participate with common shareholders in the remaining pro rata, but the common shareholders must first be paid the amount of the stipulated dividend at the same preferred rate before they share pro rata. And I will give an example later on. In the absence of any agreement, preferred shares are assumed to be non-cumulative and non-participating, to be in accord with the presumption on the doctrine of equality of shares. So let me show you an example under a book I'm reading. Oh, so please note that although preferred shares, this is tricky. Just found this in a law book I was reading. Although preferred shares cannot vote in the election of directors, as mentioned already, the grade mnemonic of Attorney Laco, if such right is deprived from them, these shares are still counted in determining whether or not the majority of the outstanding capital stock is present to constitute a quorum for such an election. Okay. Now, I'd want to show you an example given by De Leon. Example by De Leon. Simply pause the video if you'd want to read the example. Okay, let's go back to Okay, now we move on. When we talk about redeemable shares, these are shares, by the very definition, can be redeemed. And these are different from those under, wait lang a particular provision of the RCC. We will discuss redeemable shares when we go to Section 8. And then there are convertible preference shares. And when we say convertible preference shares, these are changeable by the stockholder from one class to another at a certain price and within a certain period. There's also treasury shares, and we will discuss that under Section 9, which is the last section for this title. Now, as to voting, there is voting and non-voting. I don't need to discuss that anymore. When it comes to the presence of par value, there is par and no par. Okay, now when we talk about par value shares, the minimum par value, there's actually no minimum. The minimum issue price for par value, as a general rule, it should not be issued for below par value, except treasury shares. Treasury shares, we will discuss later why they can be resold below par value. But for now, just remember that. Although there is no minimum par value, you can assign any amount, it can even be a peso. You can never issue it for below that par value that's assigned. As for legal capital, the legal capital for par value shares are those that are issued and subscribed excluding APIC or additional paid-in capital. Now, it's a different story when you're talking about no par value. When you talk about no par value, the minimum stated value by law, Section 6, is it cannot be less than 5 pesos. The minimum issue price, therefore, is also 5 pesos. The legal capital, in case of no par value shares, is different. It's actually the total consideration received because there's no such thing as additional paid-in capital when it comes to no par value shares. Now, what are the other types of shares? The other types of shares are promoter shares, escrow shares, founder shares, and watered shares. Founder shares are we will be discussing them under Section 7. So I will not go over them yet. Watered shares are those that are issued for a price below par value. So this is actually not allowed because it results in an overstatement of capital and assets. It violates the trust fund doctrine because you're selling it for below price. Sometimes actually you even sell it for no consideration at all. Now, before I move on to the others, I just want to dwell a little bit on par value. So please forgive me. I keep on going back and forth, no? But I just don't want to miss this part. And forgive me because it's just a few hours before Simbang Gabi for me. So my brains are scattered. Okay. So there's a difference between par value, book value, and market value, which I'm sure you already discussed in your basic accounting. I just want to go over them. Par value is the one indicated in the certificate of stock, picture there. Book value is the net value of total assets, capital plus surplus, divided by the number of shares issued or outstanding, while market value is the value at an arm's length transaction. What is arm's length? It is the price a willing seller would sell and a willing buyer would buy when neither of them are under abnormal pressure to buy or sell. Now, so again, bar value is not always equal to the assets of a company since the asset values fluctuate. That's why there's book value already. Par value does not reflect the actual or the true value. Now, knowing the difference between par and no par value, which is better? There's actually no right or wrong answer. On one hand, par value shares are easily sold because there is certainty as to price. There is greater protection to creditors because of the ease in computing the price of these shares. It's unlikely that it will be sold for less than its price. The However, subscribers for par value shares are liable to corporate creditors for their unpaid subscription, and the assigned par value is not always accurate in terms of its true value. On the other hand, no par value shares also have its share of benefits and disadvantages. The benefits are: one, payment is already considered full and it's non-accessible, so they are not creditors anymore because there's no unpaid amount that they will promise to pay. Two, price is flexible, so you can usually bargain for a lower price. Excuse me. Number three, it's a bit more accurate in reflecting its true value because you can always negotiate for the price of these shares. And three, dividends are more easily issued because accounting them would be easier. Why? Because when you account for the distribution of dividends to no par value shareholders, it they have, or they are entitled only to an aliquot portion. What do I mean by aliquot portion? It means that they are only entitled to a fraction of it. So if there are, say, 100,000 no par value shares and someone owns 1,000, then necessarily they are entitled to 1/100th of the dividends. Still, issuance of no par value shares can lead to one, legalizing large issues of stock for, say, piece of property, or two, they can promote the issuance of watered stock, which is illegal under Section 64, and we will discuss that later on. And three, there is lesser protection to creditors. Okay, before we move on, please note that one share equals one vote and not one vote equals one person, ha. So a stockholder may have more than one vote. We are not counting heads. We count based on shares because one's representation in a corporation depends on a stockholder's extent of ownership. So we're down to our last three sections. Please forgive me, I sat down for the first time tonight. Section 7 refers to founder shares, and it's right here, RCC. They may be given certain rights and privileges not enjoyed by the owners of other types of stock. So where the exclusive right to vote and be voted for in the election of directors is granted to founder shares, it is only limited for 5 years from the date of incorporation. In any case, they will not be given any right to vote or be voted for if if it will violate the Anti-Dummy Law or the Foreign Investments Act. So, what is this preference? Usually, they share in the profits after a certain percentage has been paid to common stock. They are often given special privileges over other stock as to voting and as to division of profits in excess of a minimum dividend on the common stock. Okay. Note that if you remember the previous section, section 6, no share may be deprived of voting rights except referred or redeemable. So, when we talk about this exclusive right, it means it does not mean that they can actually be removed of the right to vote. Because Section 6 only stated that non-voting shares may be preferred or redeemable. What we're talking about under Section 7 is the exclusive right to vote and be voted for, and no one else. That's one privilege that is given to the founder shares, excuse me. Now, when we talk about the anti-dummy law, the anti-dummy law prohibits the simulation of minimum capital stock just to falsely comply with the requirements. What does this mean? If you remember the case that I cited earlier, where there were actually nominal shareholders holding only one share of 1,500. Now, that can be considered a violation of the anti-dummy law. How about the Foreign Investments Act? Under Section 8, you don't need to look into it. I'm just letting you know that there's a list of investment areas reserved to the Philippine nationals, which we call a foreign investment negative list. So, if ever it violates that, then the founder shares cannot have exclusive right to vote. Moving on to Section 8, redeemable shares. They may be issued by the corporation when it is expressly provided in the articles. They are shares which may be purchased by the corporation from the holders of such shares upon the expiration of a fixed period, regardless of whether there is unrestricted retained earnings in the books. And the redemption must be upon such other terms and conditions stated in the articles and the certificate of stock representing these redeemable shares, subject to the rules and regulations issued by the SEC. These redeemable shares are also called callable shares. Now, you have to be careful because these redeemable shares are actually different from the redemption covered by Section 40 of the RCC. Although we will discuss this later, Section 40 is entitled Power to Acquire Own Shares. Why is it different from Section 8? Section 8 states that redeemable shares may be redeemed regardless of the existence of unrestricted retained earnings. On the other hand, Section 40 states that there must be unrestricted retained earnings to cover the shares to be purchased or acquired. And this power to purchase or acquire must be for a legitimate purpose, including elimination of fractional shares, to collect or compromise an indebtedness to the corporation arising out of unpaid subscription, and to pay dissenting or withdrawing stockholders. On the other hand, redeemable shares need not have a purpose as long as the terms and conditions are stated in the articles and in the certificate, and it's subject to the rules and regulations of the commission. Now, what do we mean when we talk about rules and regulations issued by the SEC? There is one which is precisely called Rules Governing Redeemable Shares. Under Section 5, Paragraph 5 of that rule, a corporation cannot redeem shares if it does not have sufficient assets to cover its debts and liabilities, inclusive of capital stock. Therefore, a redeemable shareholder's rights is still subordinate to those of corporate creditors. What does it mean? It means that redemption cannot be made where the corporation is insolvent or will be insolvent or unable to meet its debts after redemption. That's why there is if you remember your basic accounting, a sinking fund for redemption of redeemable shares. And what is a sinking fund? It's usually one that is deposited to a trustee bank for the redemption of redeemable shares. Another caveat, as I've already mentioned, the terms and conditions must be stated in both the articles and the certificate, otherwise not allowed. So in this case, under Section 8, Redemption rests entirely with the corporation, and the stockholder is without right to either compel or refuse the redemption of his stock. Why? Because it's already stated in the articles and in the certificate. So he or she is supposed to know that it can be called at any time. And without wanting to stress this enough, under Section 6, redeemable shares are one of the two types of shares that may be deprived of voting rights, except the I am sad mnemonic under Section 6. Alright, last. Section 9, treasury shares. These are shares of stock which have been issued and fully paid for, but subsequently reacquired by the issuing corporation through purchase, redemption, donation, or some other lawful means. Such shares may again be disposed of for a reasonable price fixed by the board of directors. What does other lawful means include? It may include forfeiture, which is allowed under Section 67, last paragraph of the RCC, on delinquency sale, and we will discuss that when we get there. So, treasury shares are not retired shares. Why? Because if you call them retired, it means they revert back to unissued shares. So since they are not retired shares, they do not revert to unissued shares. The price paid out of retained earnings for the value of the reacquired shares should be treated in the books as the payment for the purchase of such shares. And that retained earnings used to buy the treasury shares is actually an investment on such property. So they are issued, but they are not outstanding shares. Please refer back to Section 173 of the RCC. But we will discuss that also later on. So they are not a corporation's liability. So be careful, since they have already been issued before, they can be sold for less than par value because these shares were already sold for at least par value before. Though in reality, stockholders would and could complain if that price is unreasonable, if these treasury shares are resold for less than par value. No? Once resold, it becomes outstanding stock again and regains whatever dividends and voting rights it originally had. The power to resell is allowed under Section 35F of the RCC. So what are the features of treasury shares? Number 1, it has no voting rights as long as they remain in the treasury. They are uncancelled and subject to reissue. Well, why can't they vote? Well, for law is just a matter of logic. A corporation cannot be a stockholder of itself because this would enable directors to perpetuate control of the corporation. Kasi who would vote if a corporation can vote? Of course, the agent. And who's the agent? The director. So the directors can vote based on number 1, the shares that they hold, and 2, based on treasury shares. And this is exactly why treasury shares have no voting rights. The lack of a voting feature of a treasury share does not violate Section 6. Diba? Section 6, if you remember, said that only preferred and redeemable shares may be non-voting shares. Why doesn't it violate? Because treasury shares are not outstanding shares. Meaning, the provision under Section 6 stating that only preferred and redeemable shares may be non-voting refers to outstanding shares. So once these treasury shares are resold and they become outstanding again and they are reissued, you cannot deprive them of voting rights. Number 2, what is another feature? Treasury shares have no right to dividends, because it would be like a corporation declaring dividends and taking money out of one pocket and putting it into the other, because treasury shares are owned by the corporation. There's an old SEC opinion stating that stock dividend may be declared on treasury stock, even on the express condition that such will be treated as treasury stocks. What does it mean? It can be treasury stocks can be distributed as property dividends. They are not cash or stock dividends because they're treated as personal property of the corporation. And And that ends Title 1. I'm so sorry. I was aiming for an hour and a half, but I think I went overboard. Anyway, this was really discussed for 3 hours, so congratulations in effect. And I hope to see you again on our next video when we talk about Title 2, which is the incorporation and organization of private corporations. Bye!